Welcome. I am so incredibly excited you're here today because we have a truly fascinating legal procedural to break down. In this explainer, we are going to uncover a massive constitutional twist straight from the Constitutional Court of South Africa. We're looking at the case of Schabir Shaik versus the Minister of Justice and Constitutional Development. It's a case that seriously has it all. High-stakes investigations, epic clashes over fundamental human rights, and a legal blunder so significant that it completely altered the outcome of a major Supreme Court challenge.
Okay, let's dive into this. To really understand the stakes, we have to look at the fundamental question driving this entire dispute. What happens when the government's urgent, absolutely necessary fight against organized crime and corruption crashes head-on into an individual's constitutional right to remain silent? I mean, how much power should the state actually have to force you to answer questions, especially when you're the main target of their investigation? Keep this tension in mind, because it's the beating heart of the legal battle we're exploring today.
Let's set the scene really quickly. Back in August 2001, an investigation into suspected fraud and corruption began, specifically looking into some major defense armament acquisitions. By October, search warrants were executed at the premises of businessman Schabir Shaik. Just a month later, in November, he was arrested and charged with theft and various statutory offenses. And then, as the state was gearing up to add those heavy-hitting fraud and corruption charges to his file, they dropped a legal bombshell in July 2002. They issued a very specific, very powerful legal document. That document was the summons. It was issued by the Directorate of Special Operations, and it demanded that Mr. Shaik appear for questioning and produce very specific documents. Now, this wasn't just some polite request for a chat over coffee. This was a formal demand under a very specific piece of legislation, Section 28, subsection 6 of the National Prosecuting Authority Act. And it's this exact summons, and this exact subsection of the law that triggered the massive legal battle we're unpacking. And this brilliantly illustrates the core constitutional clash. It's like an unstoppable force meeting an immovable object. On one side, we have Section 28(6) of the NPA Act, giving the investigating director the power to summon and question anyone they believe has information. But on the other side, we have Section 35 of the South African Constitution, which fiercely protects the rights of arrested and accused persons, specifically your sacred right to remain silent and not be forced to give self-incriminating evidence.
So naturally, Shaik's legal team pushed back hard. They argued that because Shaik was already facing criminal charges and was about to face more for the exact same issues he was being summoned to talk about, this summons was a blatant violation of his constitutional rights. Their stance was basically that the state was forcing an accused person to sit in a chair and literally hand over the exact evidence needed to build a criminal case against themselves. Well, the High Court looked at this and effectively agreed with Shaik's lawyers on a crucial point, which rendered the immediate issue moot. Now, if you're not familiar, moot just means a dispute is no longer a live controversy. It's a closed book. The High Court determined that the words "any person" in the summons law simply could not be interpreted to include someone who was already an accused person. Because Shaik was already charged, the summons technically couldn't apply to him in the context of his own trial. And why did the High Court rule that way? Because allowing the state to interrogate an accused person like this would completely bulldoze centuries of well-established criminal procedure. Specifically, Section 196(1) of A of the Criminal Procedure Act explicitly states that an accused person is a competent witness, sure, but they can only be called to testify upon their own application. You can't just force them to the stand. Recognizing this, the state actually backed down and conceded they couldn't question him regarding his pending charges under that specific summons.
So, if the state backed down, and the High Court agreed that the summons couldn't be used against him, you might be wondering, why on earth did Shaik's legal team take this all the way to the Constitutional Court? And even more baffling, why did the highest court in the land ultimately dismiss his appeal to strike down the law?
The answer lies in an incredible, almost unbelievable technical twist. Delivering the judgment of the Constitutional Court, Justice Ackerman wrote this absolutely devastating line: "The wrong statutory provision has been targeted for constitutional attack." No way, right? The legal team had aimed all their firepower, all their brilliant constitutional arguments at the completely wrong part of the law.
Now, what's really interesting about this is how the mistake actually happened. Shaik's lawyers attacked Section 28(6), but 28(6) merely describes the administrative power to issue a summons. It doesn't actually force anyone to do anything. The real teeth of the law, the actual sting of compulsion, the threat of punishment for not answering, and the limits on your right to remain silent, all of that is entirely contained in Sections 28(8) and 28(10). The lawyers attacked the vehicle, not the weapon itself.
You see, in constitutional law, specificity is literally everything. The Constitutional Court made it crystal clear. Declaring a law passed by Parliament invalid is a massively serious matter. It's one branch of government striking down the work of another. Because of this, a court cannot simply strike down a law based on implied arguments or because the lawyers aimed at the wrong subsection. You have to be exact.
But wait, the Constitutional Court didn't stop there. They also called out a huge mistake made by the High Court, and it all comes down to the principle of objective invalidity. This principle dictates that when you judge if a law is constitutional, you have to look at all its potential applications objectively. You can't just look at the specific subjective position of the two parties currently fighting in the courtroom. A law is either valid for everyone or it's valid for no one.
The High Court essentially got tunnel vision. They justified the heavy-handed nature of Section 28 by looking specifically at Shaik's case, which obviously involved highly serious allegations of fraud and corruption in a massive national arms deal. The High Court basically said, well, because these specific crimes are so severe, the state's harsh investigatory powers are justified. But according to the Constitutional Court, that is completely the wrong way to look at the law. To prove this, the Constitutional Court looked at the actual text to see what else could trigger these extreme interrogation powers. And it turns out, Section 28 can be triggered by any offense committed in an organized fashion. Look at this list: violations of the Income Tax Act, the Customs and Excise Act, and, amazingly, the Sea Fishery Act. Yes, you heard that right. If a group of people get together and organize to illegally catch some fish, they could theoretically be subjected to these severe, rights-limiting, closed-door interrogations. It's totally absurd when you think about it. This just demonstrates the sweeping, almost terrifying power of the statute. The Constitutional Court noted that to truly test if this law is constitutional, the state must justify removing the right to silence not just for an international arms dealer, but for a local fisherman violating the Sea Fishery Act. Because the High Court failed to evaluate the law against its most trivial potential applications, their entire justification analysis was deeply flawed. Now, even though they aimed at the wrong subsection, Shaik's team did bring forward one final, absolutely crucial argument: the issue of immunity. Think about it. When you are forced by the state to answer questions, what kind of legal protection or immunity do you actually deserve? Shaik's team argued heavily that the direct use immunity provided by the NPA Act was entirely insufficient under the Constitution. To unpack this, we need to look at the 3 levels of immunity the court considered, drawing from a landmark precedent known as Ferreira versus Levin. First, there's transactional immunity. This is total protection from being prosecuted for anything you admit to. Second is direct and derivative use immunity, meaning the state can't use your answers against you, and they also can't use any outside evidence they only found because of your answers. Finally, there's direct use immunity, where only the spoken answers themselves are protected, but the state can still go investigate leads based on what you said.
So, the Constitutional Court clarified that in South Africa, direct use immunity is actually considered constitutionally sufficient. They rejected arguments based on Canadian law that demanded higher levels of immunity. The court's logic here is that we have to trust the trial judge. If the state finds derivative evidence based on a forced confession, it is entirely up to the trial judge's discretion to exclude that evidence during the actual trial to ensure fairness.
Now, before wrapping up the judgment, Justice Ackerman left the legal community with a pretty chilling, ominous warning regarding how these interrogations actually take place. The law requires these proceedings to happen in camera. That means proceedings held entirely in secret, behind closed doors, without the public or the media present. So the crucial point is this lingering danger of unchecked power. Section 28(3) allows these secret proceedings to take place without any independent arbiter like a judge or magistrate in the room. The investigating director or their designate can question a suspect under oath in a closed room with absolutely no independent oversight required by the statute to ensure the person's rights aren't being abused right there in the moment. The judgment literally paints this specter of unfairness. Just picture it: an interrogator and an interrogatee locked alone in a room for days. The interrogator asks all the questions, and under the law, the session is recorded in whatever manner the investigating director deems fit. Maybe it's an audio recording, or maybe it's just the interrogator taking their own handwritten notes. It is a massive, completely unchecked power dynamic. The court warned that this represents a really dangerous shift from an accusatorial justice system, where the state must independently prove your guilt, to an inquisitorial one, where the state literally forces you to help them investigate you. So while Shaik's appeal failed on a technicality because his lawyers cited the wrong subsection, the Constitutional Court practically sent up a flare. They signaled that these frighteningly broad interrogation powers desperately need to be challenged with properly prepared legal papers in the future.
Which leaves us with this final vital question. How do we balance the necessary fight against organized crime with the absolute protection of a fair trial? If the state can't effectively investigate corruption without forcing answers, are we willing to sacrifice our fundamental right to silence? It's a massive tightrope walk between security and liberty. Think about that the next time you hear about a high-profile corruption sweep. Thank you so much for joining me on this explainer, and keep questioning the structures around you.